Hi, Guy Lawton the Law Guy here. Today I want to talk to you about Let's Play videos. This here is Felix Schellberg, or more commonly known as PewDiePie. He has the most user subscriptions on YouTube, with just over 36 million. And what exactly does PewDiePie do? Well, he's famous for recording himself playing video games and uploading it onto YouTube, or in other words, producing Let's Play videos. Let's Play videos is the recording of computer content where the player adds value through commentary, sometimes accompanied with an image of the player while he is playing the game. But do these Let's Play videos infringe copyright under Australian law? It's a difficult question to answer because it could depend on the style of video game and how the producers are using that content in their videos. There are many ways in which copyright could subsist in a video game. For example, under Section 10 of the Copyright Act, computer program is considered a literary work. Also, musical scores within the video game would be considered a musical work under Part 3 of the Copyright Act. Part 4 of the Copyright Act would mean that copyright subsists in the sound recording. Sega Enterprises Limited and Galaxy Enterprise Proprietary Limited says that copyright subsists in the computer game as a cinematograph film. The respondent argued that Virtua Cop did not have copyright as a cinematographic film because it wasn't represented until the image was displayed on the screen. It wasn't like a traditional film in that it sequentially played back 2D images from start to finish. The Federal Court of Australia came to the conclusion that video games did have cinematographic film copyright because it didn't matter how the images were produced, all that mattered was the end result. Justice Burchett reasoned that Virtua Cop was like a traditional film in that it had two protagonists whose goal was to bring down a criminal organization, and that it had a start, a middle, and an end. That if the player put the right cues in and right directions in the game, that they would see the simple story from start, middle, and end. It makes you wonder if they would have come to a different finding if the subject of the dispute was a sandbox game, something like Minecraft, which has less limitation on a player's input, which doesn't really have a beginning, middle, or end. If you follow the reasoning of Justice Burchett and how much he considered the likeness of a video game to a film, then sandbox games like Minecraft wouldn't really match up with that reasoning. There are a few ways in which a Let's Play video could infringe on a copyright owner's exclusive rights, but the most obvious and blatant one is that they're communicating the work to the public, which is an exclusive right of the copyright owner for both Part 3 works and Part 4 copyrights other than work. Communicate means to make available online or to transmit electronically copyright material. However, there are fair dealing provisions in the Copyright Act which curtail the exclusive rights of copyright owners. They permit the use of copyright material without the need to get authorization from the copyright owner when it's used for specific purposes. You can use the material for the purpose of research and study, criticism and review, parody and satire, or for reporting the news. I think it's highly likely that Let's Play videos that emphasize bugs and glitches would fall under the fair dealing provision, especially for criticism and review. Take for example Activision's attempt to take down videos that highlighted Call of Duty's glitches. Ultimately though, it would be based on what the video's purpose is. Is it for criticism, review, or entertainment? With most Let's Play videos being for entertainment, and they would be breaching the exclusive rights of communicating to the public that copyright owners have.